Have you ever wondered why constitutional rights sometimes seem to apply differently depending on where you are? The way our system is set up, with power shared between national and state governments, plays a huge role. Federalism significantly impacts equal protection enforcement by creating a complex, multi-layered system where both federal and state governments have distinct, yet often overlapping, responsibilities. This division of power means that while the core guarantee of equal protection remains constant, its practical application and enforcement can vary considerably across different jurisdictions. The fundamental reason for this lies in the dual sovereignty inherent in American federalism. The Equal Protection Clause is found in the 14th Amendment to the United States Constitution, which was ratified after the Civil War specifically to ensure that states provided equal rights to their citizens. This amendment directly applies to state and local governments, making it a critical federal check on their power. While the United States Supreme Court sets the constitutional floor for equal protection standards through its interpretations, ruling on cases that define the scope and limits of the clause, states are also free to offer greater protections to their citizens under their own constitutions and laws. This means that, for example, a state might adopt stricter anti-discrimination statutes than required by federal law. Conversely, if a state's interpretation falls below the federal standard, it can be challenged. Congress also plays a role, with its power under Section 5 of the 14th Amendment, allowing it to enact legislation, such as parts of the landmark Civil Rights Act, to enforce the provisions of the amendment. This creates a multifaceted enforcement landscape, where actions by federal courts, federal agencies like the Department of Justice, and state-level institutions all contribute to, and sometimes complicate, the consistent application of equal protection principles. For individuals seeking to ensure their equal protection rights are upheld, understanding these layers is crucial. Federal courts, for instance, serve as ultimate arbiters of federal constitutional claims, providing a vital avenue for redress when state actions are alleged to violate the Equal Protection Clause. However, many cases are initially litigated in state courts, which are also bound to uphold the federal Constitution, alongside their own state constitutional provisions. Citizens can engage with their state legislatures and local governments to advocate for stronger equal protection laws and enforcement mechanisms, recognizing that states often have latitude to expand upon federal minimums. An interesting aspect of this interplay is the doctrine of selective incorporation, where fundamental rights from the Bill of Rights, initially only binding on the federal government, have been applied to the states through the 14th Amendment's Due Process Clause. This includes elements pertinent to equal protection, ensuring a baseline of rights across the nation. Another nuanced point is 11th Amendment immunity, which generally protects states from being sued in federal court by private citizens without their consent, thereby influencing the types of enforcement actions that can be pursued. Ultimately, federalism ensures that equal protection enforcement is not a monolithic federal mandate, but rather a dynamic negotiation between national standards and local realities. This necessitates an informed citizenry who can navigate the various levels of government to assert their rights, understanding that both federal oversight and state-level action are essential components of a robust system of equal justice under the law.